medical condition worsened, which meant that he had to go to hospital, so he won't be there present in court, but the court is likely to hear more about his medical condition as a part of the arguments being laid forward for a bail. Let's listen in.
Writing that at the appeal we would get the latest update on the appellant's medical condition so that the court dealing with the appeal would be in a position to decide, more particularly where we've raised certain points in regards to his medical condition from the 1st of October, which pre-existed the 14th of October, which was the actual bail application. So it's not a matter of introducing something new, and the Supreme Court Act provides that you can introduce this on appeal. We didn't have this information at the time. This is as of this morning, and I think it's an important factor that the court should take into account. But I suppose in view of the history of this matter and what happened previously on the 14th of October, only with one of my learned friends, this is the kind of attitude I should have expected, as you'll see from the record. So my submission would be that you can most definitely take it into account. It's a most important critical point relating to the question of whether or not he should be released on bail, and you'll see I have set it out in my heads of argument, and we did notify the appellants, the respondents in writing that we would be introducing this at the appeal. We would produce a medical certificate or something from the specialist physician as to his present condition, because I think it's important for your lordships to consider the matter overall in view of all the various factors. So that would be our respectful submission, and we would request you to please take this into account. Thank you, my Lord.
Yeah, just one last aspect, Mr. Rousseau.
Yeah.
Isn't it predicated on the admissions the state made about the appellant's condition as at the time of the argument of the bail application?
Lord,
that you concede that he has got some chronic illnesses.
Lord, as far as the evidence was before
Yeah.
the court of court,
Yes.
it's not a contention. It's not,
Yes.
But unfortunately for the appellant, Section 65 of the Criminal Procedure Act
Yes.
says as follows, reads as follows: an appeal shall not lie in respect of new facts which arise or are discovered after the decision against the appeal is brought, unless such new facts are first placed before a magistrate or regional magistrate against whose decision the appeal is brought, and such magistrate or regional magistrate gives a decision against the accused on such new facts. And the Lord, the wording used is
New facts.
shall.
Shall.
No, please.
Okay. Okay, yes, let's see you further, Mr.
Yes, thank you, my Lord, as your Lordship pleases. My Lord, we have set out heads of argument which we uploaded on case lines. We also emailed them to you together with the relevant case law. We've also made copies, and we've also provided my learned friend with the exact same that you Lordship has. Lord, you'll see now heads of argument, and I'd like specifically to deal with the charge, common cause, what the charge is. The appellant, unlike accused 2 and accused 3, accused 1 and 2 in this matter, he is accused number 3, has been charged with 1 count of corruption. There are 2 amounts of approximately 620,000 rand, which the appellant alleges was the money belonging to Bosasa and or the late Mr. Gavin Watson and or the African global group of companies. And there was further an amount of approximately 200,000 rand being a security installation, which we submit was on the instruction of the late Gavin Watson at the private residence of accused number 1. So that is the charge on which the bail was refused. It's just that 1 count. You will see there are 2 further charges which relate only to accused number 3. That is Mr. Smith himself. It has to do with fraud, and it also has to do with non-disclosure in terms of his duties as a parliamentarian. That does not apply to accused number 3, who's the appellant. Now, it's common cause, and we submit this, you'll see this at paragraph 6. There was an agreement arranged between ourselves and the state that if and when the appellant was required, he would by agreement report to the investigating officer, and if the state decided to charge him, he'd appear in court on a date to be arranged, and bail would be fixed and not opposed by the state. You'll see it's common cause at paragraph 8 that on the 1st of October, the medical certificates relating to the fact that the appellant had been hospitalized and could not appear on the 1st of October were handed in and signed and accepted by my learned friend acting on behalf of the state. And this set out what the position was, that the appellant had unfortunately been hospitalized with emergency treatment, and he was now dependent on oxygen, and he had to have a large oxygen tank together with the portable one that he brought to court. And it seemed to me there was no dispute, as you correctly pointed out to my learned friend, relating to the pre-existing comorbidities as well as the position. What then happened is we submit in particular, and you'll find this at paragraph 9 of our heads of argument, that the learned magistrate urged, especially in view of this undisputed evidence as to his chronic medical condition, the severe risk of his comorbidities, and the increasing rise of COVID-19 cases, in particular at Johannesburg Central Prison, known as Sun City. And we refer specifically to paragraph 24, which is Exhibit D, where the appellant in this matter set out, it was not disputed by the state, that in his answering affidavit he said he has a current medical condition together with comorbidities as well as the unfortunate increase of COVID-19, especially in the Department of Correctional Services and in particular the Johannesburg Central Prison. And what we've done for you, my Lord, the Directorate of Prisons, who is now the Honourable Justice Cameron, one of your brothers who sat in these courts with you previously, he is now in charge of the prisons nationwide, and he himself in May of this year visited the Johannesburg prison, Sun City, and you have the article in front of you. We've attached this as one of the exhibits where he said as follows: the visit to Sun City prison is a nightmare to manage the virus in the confined spaces. And the learned judge then dealt with the position and what he himself found together with his team from the Directorate of Prisons at the Johannesburg prison. And as it was placed on record, unfortunately the previous head of the prison actually passed away from COVID, as well as another senior official. It's been rife in that particular prison as well as other prisons in the Republic of South Africa.
Excuse me, sorry, just before you proceed. This document by Justice Cameron,
yes,
is it handed in by as common cause? Relating to whether it's new evidence or not, seems to Rousseau.
New evidence that what it seems to want to introduce during the field. I am already very supporting that regard. My submission that, again, new evidence should be introduced in the court of quote where an application on new facts can be proved.
Okay. Yeah, you may proceed.
Very, very simple, my Lord. Look at Exhibit D. Look at the replying affidavit of Mr. Agrizzi, paragraph 24. He deals with his comorbidities and he deals specifically with COVID at the Johannesburg prison. It's not new evidence. All that it is simply being supported by the Directorate of Inspectorate of the South African Corrective Services. That is all it is there for. That is not new evidence. Mr. Agrizzi himself put it in his affidavit. So I'm not sure where my learned friend was when we were dealing with the matter, but it's in front of him in the affidavit, paragraph 24, Exhibit D. But what we've then done, my Lord, we respectfully refer you in regards to the case law dealing with this, and in paragraph 10 you'll find we refer your Lordship, and we provided my learned friend as well as your Lordship with the cases. How the United States of America, who are one of the countries that unfortunately, even though it's a world pandemic, how have they been dealing with COVID-19 in the detention centres? And we've attached and provided for you, my Lord, the matter of Josephina Coronel and Thomas Decker in the United States District Court for the Southern District of New York, together with the decision of the United States District Court, Central District, California, Western Division. There are more that I've got, but I didn't want to burden your Lordship with it. But we want to, and we actually inviting your Lordship to possibly, and I think it will be a first, to develop the law in the Republic of South Africa as to how do you deal with COVID-19, people with comorbidities where there is this before you in regards to further detaining them in a corrective facility. And in particular, we set out in the case law how the United States of America has been dealing with matters relating to COVID-19 and detainees who suffer from medical conditions and comorbidities. So there were various class actions brought in the United States of America. We have provided your Lordship with the case law, and what the Americans did, and I've taken it across. So we took from California and we obviously took from New York, where the virus was hit at its, if you can call it, its hardest. And what the courts there decided, and this went all the way through to the appeals court, and we have provided you with the decision. They decided that if you've got somebody in detention who has got comorbidities, and there is a serious risk if you keep them in a detention centre that they might obviously be infected with COVID-19 because of the overcrowding, the space is exactly what the learned Justice Cameron said, then it is better to release them on bail. And we did include this in paragraph 24 of Exhibit D. The appellant in this matter said, this is the position that I've got these comorbidities, it seems to say to accept the comorbidities, not the evidence, and this is how you should deal with it. So we've submitted, and I'm not going to quote the cases because you have them in front of you and it would just take up time, you already have them. We then dealt with respect of the matter of State versus Mabapa, M-A-B-A-P-A, which is 2003, volume 2, the South African Criminal Law Reports, page 579 of the decision of the Transvaal Provincial Division, as it then was, at page 587G. And in that particular case, which I have with me, the learned judge referred to some of the other judges who dealt with similar matters, and they said the risks of prison life and incarceration and the protection of the appellant's dignity, whether in the circumstances and the rights of the community, it would be reasonable. And what they did in the Mabapa case, they said you have to take into account that unfortunately there is this problem in regards to prison life and in regards to facilities or lack of facilities, and you need to take this into account when you're considering the freedom and liberty of the individual. And Mabapa was actually a matter, as the Lordship will know, where the person had been convicted and sentenced and was on appeal. This case has been no trial, there's no conviction. It's also common cause that the appellant in this matter has no previous convictions. We then, with respect, my Lord, refer you to the matter of S versus C, which is a 1996 volume 2, the South African Criminal Law Reports at page 503, where the learned judge of appeal, and it appears also it was the Honourable Justice Cameron already in 1996, at page 512 specifically, he dealt with the ill health of an offender, and this is where somebody had been sentenced and somebody unfortunately had a serious medical illness, and you have the case in front of you, and there was a risk of imprisonment having a gravely adverse effect on the offender's health, and we submit that the learned magistrate erred in this regard and was not considering bail conditions, especially when he had the evidence of the appellant's chronic medical condition. Now, my Lord, we're not saying that every single person who has a severe chronic medical condition, depending on the charge, depending what it is, because of the problem of COVID, that you automatically would be excused and you wouldn't be released on bail. We're saying if you take the totality of the evidence in this matter and the totality of the appellant's personal circumstances, that at the end of the day, and especially in view of his now present medical condition, which is not something that he called for. It's not something that, if it was there, it was a comorbidity, and unfortunately, we haven't got the medical evidence what caused it, but they first moved into a public hospital, which is the one that's linked to Johannesburg prison, and thereafter the professors at that hospital said, this condition is so serious, you need to move him back to the specialist physician, etc., and he was then moved to a private hospital where common cause he's in custody, his leg is chained to the bed, which I don't think it's in terms of prison conditions, we can't in any way object, because that is what the directive, and we have communicated with the Honourable Justice Cameron and said, but the man is on a ventilator, the man is not conscious, how can you chain him to a bed? There's 3 people from the department inside his ward guarding him, all armed. The regulations say 2. We don't mind that there's 3, but the doctors can't have the same freedom to deal with and attend to somebody who's critically ill with 3 people in. There's 3 people outside the door, which we've got no problem with. They're not in his intensive care ward where he's alone and he's chained to the bed. And then there's 3 in the car park. We've got no problem with the people in the car park from the Department of Corrective Services. Even though the regulations talk about 2 depending upon the risk or high risk, etc. But at this stage, in view of his medical condition, it seems to me, and in our discussions, it's not conducive to treating him in the condition that he is. And if he was released on bail and he's now not chained to the bed and he can now possibly have access to the family member, life would be a lot easier if he was released on bail together with conditions. And that's really the submission that we make in that particular respect. Now, we then deal with a very, it's a difficult thing to deal with, but there is fortunately case law to this. Now, there was an agreement in existence. I don't think there's any dispute that there was an agreement. The agreement was not with myself and Advocate Rousseau, because he wasn't dealing with the matter at this stage. He's dealing with different matters, but not this particular matter relating to the case at Palm Ridge. My learned friend who sits next to him, who I've known since Johannesburg Magistrate Court days, and she's progressed right through the ranks, and she's now at the special unit. There was an agreement between the two of us all along. And in fact, even on the evening before, we'd already arranged that the appellant is on the record. You'll see when you read the record. Please go to Brackendown, just be processed. Please come to court. The only, if anything, where there was a slight disagreement was on the amount of bail. We were just discussing what the amount would be. Our submission was, well, if Mr. Smith's been released on 30,000 Rand, why should we be treated differently? Yes, we are appearing Friday the 16th in Pretoria. We've got no previous convictions. It's a pending case. So it's Schedule 5. So we were just talking about the amount. And I think what is important in this regard is we've referred you with the utmost of respect that if you look at this, that the National Prosecuting Authority, and I need to raise this, and I don't raise this against one of my learned friends, have got a particular code of conduct. And I've got the code of conduct. I think we've attached it to our heads of argument. And there's actually case law saying that if a prosecutor, he or her, gives their word to the defense, the word is their bond, they must stick to their word. And there is case law, which I can quote to you, my lord, I think you're aware of it, a very, very good decision being with plea and sentence agreements, where you can't then take an unfair advantage and then trial by ambush. So I think that your code of conduct is something that is very, very important, so much so that the National Prosecuting Authority Act enacted an act how prosecutors should conduct themselves. And I don't want to make too much of this, but all I'm really saying is there was an agreement up and until, if one wants to call it, the 24th hour, the last minute.
As I read the paper, sorry, wasn't it superseded by an exigency which was not foreseen when this agreement was allegedly entered into?
No, not at all.
Oh, I see.
Not at all. If it was, then what my learned friend would have done is she would have said, listen, we've got certain information. I'm not going to trial you by ambush. Let me forward you the information. We've now decided we're going to oppose. You don't lead an opponent or an accused or the appellant in this matter. You don't lead them into the line with them. You don't say, come to court, go get processed. We're not opposing bail. We've just got to talk about the amount. And you'll see, there was even a draft order. And in fact, I see my learned friend in his submission says the big problem is because of these assets, we're not sure of what amount of bail should have been fixed. So it seems there wasn't this real opposition to bail as it appears, but then it turned around and took, unfortunately, a turn for the worse. And with the utmost of respect, my lord, when you're dealing with colleagues, whether you're the prosecution or whether you're the defense, it doesn't make any difference. There is this code of conduct. We abide by a code of conduct as well in regards to the our word is our honour. That is all we've got is our integrity and our word, and I think most counsel and all counsel and attorneys should deal with matters in that regard. And you don't expect as you arrive to actually get trial by ambush, and then you have to do replying affidavits. And because of his medical condition, we couldn't delay the matter. We had to then proceed, because you could see, with the utmost respect, my lenders could see the condition that he was in on permanent oxygen. Even the magistrate, as you'll see from the record, remarked that he wasn't taking it very, very well. Whether it was opposed or not, he was struggling just to be in the witness box. And it appears that his medical condition, this was his first appearance in public, as you'll see from the letter handed in. And what we say very, very simply is that, and I have the case law here, where the learned judge dealing with a similar matter said, the prosecutor gives you his or her word. That is the end of the matter. That word is their honour and their bond. So I would put it as high as that, and I'm not going to deal with that any further. The next aspect, and I think this is an important aspect, my lord, is the strength of the state's case. Now, something is glaringly missing from the affidavit of the investigating officer in the matter, Colonel Lazarus. He gives a whole thing in regards to the financial transactions, and I just want to pause and stop with the financial transactions as we address the court. If these transactions, with respect, my lord, were done without Reserve Bank approval and without the South African Revenue Service's knowledge, well then, as I addressed the learned regional magistrate, it's a whole different story, because then it shows a different modus operandi of an appellant in the matter. But everything, even included in Colonel Lazarus' affidavit, was done in terms of the offshore allowance as a local resident. Everything was declared to the South African Revenue Services, and all the funds, etc., everything had been declared and done through the South African Reserve Bank with approval. And when you take that into account, with all the other roots of family, grandchildren, his brother's family in the Republic of South Africa, then you start to look. And then, surprisingly, when dealing with the matter, not one word, not one iota of evidence is given by Colonel Lazarus to say, this, by the way, I've changed my mind because I've seen a movement of assets and I've seen financial transactions where it seems that he's invested overseas with Reserve Bank approval, but he doesn't say anything about the case that he's facing. All you have, and all the learned regional magistrate had, was the viva voce of what my learned friend Advocate Bosasa told the court, that the National Prosecuting Authority wouldn't bring a case to court if they didn't think they had a good case. That is not sufficient. You require evidence on oath from the investigating officer to say, these are the reasons why I say he's a flight risk. These are the reasons why I say the state has got a very, very strong case against him, which would not prevent an appellant being released on bail, but with the utmost respect, there's absolutely nothing. And we've referred your Lordship in particular to Section 16, subsection 11, subsection A of the Act, where the strength of the state case was dealt with, and we refer you to the Botha matter. And we say very, very simply that if no attention, proper attention is paid to that, then that in itself is a misdirection. And we've quoted you the case law, and there's a copy of the case in front of you. And what is important, and we pointed this out in our heads of argument, my lord, where the learned regional magistrate said, well, your learned friend has said that they have a prima facie case, but what the facts show is a very carefully crafted draft indictment. What the facts show, what do the facts show in this particular case? That 2 payments are made to accused number 3 in this matter. The payments come from Bosasa money, and the payments come from either Bosasa and or the late Mr. Gavin Watson. No payments come from the appellant in this particular matter. Now, unfortunately, because of the tragedy that befell the Watson family and the untimely and unfortunate death of the late Mr. Gavin Watson, which I think is not a new fact, I think it's common cause, unfortunately, that he deceased as a result of a car accident. What is the state left with? We can't charge the late Mr. Gavin Watson, and we can't charge the Bosasa to be liquidated, although there are court applications to take it out of liquidation. It doesn't exist, and it's a final liquidation, so we haven't got an accused. So we can't charge the company because it's the company's money held with an attorney, and certain cash paid by one of the accountants, I'm not going to mention a name in open court, part of the indictment, certain cash paid into the Euro Blitz 48 Pty Limited, that's the company apparently of the third accused in this matter. So what does the state now allege? They say, well, when the money was paid in, which appeared to be for the university fees of the third accused daughter, who was studying in Wales, there had to be some form, in terms of the Corruption Act, a benefit, a gratification. So if you're giving me the gratification, I will then do something in exchange for you. But was the gratification to the appellant in this matter, who stood to gain absolutely nothing, not his money, or the gratification for the benefit of Bosasa, who had all the tenders and were getting all the tenders from the Department of Corrective Services. So that's in essence when we talk about the strength of the state case. But the investigating officer says nothing. He doesn't say anything at all as to where does the appellant in this matter fit. My learned friend, as you'll see in his heads of argument, when we talk about introducing new facts, he's now trying to argue his matter to say, well, this was common cause, it had already been mentioned in Parliament, and we don't really need what the appellant told the State Commission, State Capture Commission. We believe that we've got a case. He doesn't put it in the affidavit of the investigating officer. He doesn't even submit this at the hearing. So this is an important fact we submit with respect that the learned regional magistrate heard in regard to the strength of the state's case. We then deal with the case law. I'm not going to go into the case law, my Lord, because you know all the case law, but the only important one that we think you should pay with respect to utmost of attention is what the Constitutional Court said in the matter of State versus Lamili, Glad and others, Rubert and Schitterka, which we've quoted there, where the learned judges, full bench, all 11 judges in the Constitutional Court said not only the innocent are entitled to be released on bail pending trial, on the contrary, even those who've been convicted and sentenced to imprisonment can be and are often released on bail pending appeal. And at page 822 of the Constitutional Court, they said as follows, and I think this is important in view of what the Honourable Justice Cameron said as the Director of the Corrective Services. Bail serves not only the liberty interests of the accused, but the public interest by reducing the high number of awaiting trial prisoners, clogging an already overcrowded correctional system, and by reducing the number of families deprived of a breadwinner. And the case law has been set out in that for you, my Lord. Lord, then the other important aspect to take into account, and we especially ask you to take into account when you submit the learned magistrate erred, was his finding that the interest of justice does not permit the release of the appellant. And at the end of the day, we say where the learned magistrate erred in this regard is that he didn't take into account not only the affidavit, but also the replying and answering affidavits, exhibit C and D that were submitted with respect to the regional court, the Specialised Commercial Crimes Court at Farm Region to Causa. He didn't take into account you dealing with a person who has got no previous convictions. You didn't take into account the assistance and cooperation that is given not only to the state capture but to various other entities of the state, including the revenue services and the special investigation unit in the Republic of South Africa. We then deal with another important aspect when you submit with respect to the learned magistrate has erred. And now we deal with the crux of what the state was saying, where they said, well, if he's got these assets and these assets are more than what you said previously, well then what amount of bail can you give him? Now you don't, if you look at State versus Mohammed, with the utmost of respect, old 1977 decision, what they said was don't set bail so high as to not amount and not be tantamount to granting bail at all. So it seems that my learned friend was struggling with that concept. Yes, if we agreed to bail, what amount of bail did he get? Because he's a man of assets, and that was his submission before the learned regional magistrate in Palm Region. He says, well, he's not, you can't treat him like any other person because he seems to have more than your average person that appears in these courts. That is a complete wrong concept, and Mohammed, that matter dealt with it. And what we've set out for you, we've set out and we've attached a decision of the Supreme Court of Appeal. It's an unreported decision, and we've given both you, my Lord, as well as my learned friend a copy, and that's the matter of Joseph Wilkinson. Now, that matter, which you have before you, my Lord, was an extremely, very, very serious matter. It's still ongoing, by the way. It hasn't. Apparently, they're starting in February next year on trial. And what happened is the appellant in that matter, he refused bail, he got an appeal, bail refused, he then landed up in the Supreme Court of Appeal. And the learned judges of appeal, Kacharia, Majid and Gorban, who was the acting judge of appeal, dealt with this, and this was a racketeering, intimidation and unlawful sale relating to rhino horn, money laundering, keeping of protected animals, and there were even further more serious charges against him. And in particular, what we referred your Lordship to was a severe misdirection in this matter. And you'll find this on page 5 of the judgment. And this was taking on a judge, not the regional magistrate, a judge, at paragraph 6. And he said as follows, the learned judges of appeal. A further misdirection is the approach adopted by the learned judge in respect to the appellant's substantial assets. Jordan J. regarded the fact that he's a wealthy individual as a factor against the granting of bail. He said the appellant would have no qualms about forfeiting any amount of bail fixed by the court given the severe sentence. Now, the sentence in that case is a sentence of, with money laundering, prevention of organised crime, you're talking about minimum sentences, you're talking up to 30 years in prison. So that was what he faced, and the state alleged they had a good case against him. And the reasoning is with respect illogical because of the severe sentence he faces. He that wealthy individuals would face an extra hurdle to overcome, particularly where they apply for bail in serious cases with charges which carry severe penalties upon conviction. These misdirections constitute an improper exercise of the High Court's discretion. We are thus at large to consider the question of the appellant's release on bail afresh. And then further, in that case, a very, very illustrative matter, further interference on appeal was that the High Court, in the Wilkinson matter, failed to give any consideration to the imposition of suitable conditions as an alternative to refusing bail altogether. And the learned judge of the appeal said, in a bail application, regardless of the nature of the charge or charges, the point of departure in deciding whether or not to grant bail is Section 35(1)(f) of the Constitution, which provides that everyone who is released for allegedly committing an offence has the right to be released from detention if the interest of justice permits, subject to reasonable conditions. And the bail provisions of the Criminal Procedure Act 51 of 1977 expand on and seek to give effect to this constitutional imperative. And our submission that we've submitted to you in this particular regard, based on that case alone, is that this is indeed, and I think with respect, when my learned friend gave us the draft order, you'll see it's part of the court record, it seemed to be some severe restrictions in regards to conditions, reporting, not applying for new travel documents, not approaching any near a border, etc. We had no problem with that. It would have been a matter of discussing it as colleagues between us and then preparing and handing up. But the draft order, as you'll see, was handed up as part of the pack that was given to us with a little surprise that we got on the 14th of October. So we've set it out in our heads of argument when we submit, if your Lordship is in favour and your Lordship does find in fact that we have submitted these misdirections and these, one wants to call it, the exercise of discretion of the learned regional magistrate, we've submitted, and you'll see it in our heads of argument. Then, in this particular regard, the learned magistrate, and I say this with the utmost respect because he dealt with the matter, he sat lately after 4, and I think, with respect, Lord, you could see, I knew from my experience, many years of experience, the cash office closes at 3:30. So if you're going to sit for 4:20, your chances of getting bail are probably negligible, because even if you get it, where you're going to pay, court would have been closed. And we sat for 4:20. But what the learned magistrate did, he questioned my learned friend, and he said, well, what about these conditions? What about if you contact the Italian embassy, which has already been notified, no further travel documents? What happens if you contact Home Affairs? And then what the learned magistrate did, and I think with the utmost of respect, you can't hold this against the appellant in this matter, because there's nothing from the investigating officer to say he's attempted to escape. And in fact, Common Cause, the investigating officer, supported his travel overseas. And up until the state capture requested him, please don't go, cancel your trip because we're still busy with certain important aspects. And the investigating officer is not disputed by the state. The same one who made the affidavit said, I've got the passport, if you want to go, I've got no objection at all. And I can place it on record, there was no dispute at all. He was more than willing to assist. And what we say is as follows, in this particular regard, that when you deal with the presumption, and you'll find this in paragraph 28 of innocence and your constitutional right, we say that unfortunately we lost sight of this important legal principle. And the point is, if South African borders are porous, as the learned magistrate said, that doesn't mean that every single person who appears in our courts of law, whatever the charges are, whether it's a district court, regional court, or the High Court, you now say, well, that's the reason why I can't give bail, because the borders are porous. If you've got evidence from the investigating officer, or you've got independent evidence to say, well, we've got information that he or she has booked a one-way ticket, they booked tonight out of Oliver Tambo Airport, or they're going on a private plane via Lanseria, that's something different. But because of the fact that they say the borders are porous, that can never ever be a reason not to grant bail. And we submit that we had the full support of the investigating officers who wanted to return the passport, and up until the state capture, the learned Deputy Chief Justice requested, please, you can cancel your trip, which had been pre-booked, the itinerary was given, the dates, the accommodation, etc., which was business, and also part leisure, and all this was placed before the court.
Sorry, was this before the Italian passport was lost?
Yes, long before that.
I see. Just tell me,
Yes,
just as a matter of procedure,
yes.
When a passport is lost and you report to the particular embassy or consulate,
they're in Houghton.
yeah, do they immediately cancel that lost passport, or what do? They just say, oh,
no, I'm sure that passport, we just dealt with them in mail. I've got no doubt that will be immediately cancelled. If it's lost, they don't want to fall into the hands of someone else. It's very easy for somebody to take a picture and put the picture in. So I've got no doubt they cancel it. That's why we attached a copy, which you'll see as part of the papers, of the passport with the number, so they could see this is the one you're dealing with. It's not any other passport. So my understanding is dealing with other consulates, not with that consulate, they immediately cancel that passport. So nobody else can use that passport. As long as it's reported to them, it was done. And when it was requested, we found this out and we immediately reported. And the important thing is that the advocate, the senior state advocate dealing with the matter, who's not here in court today, my other learned friend was assisting him. She's dealing with one of the related matters in the Pretoria Commercial Crime at this stage. When this was canvassed and this was set out before the court, he wanted it, and Colonel Lazarus deals with it. He said, please just give us an affidavit, just explaining the circumstances, where it was lost, and what did you do when you found out it was lost. This was done probably August last year. So in 14, 15 months, absolutely no problem at all to say, well, we don't accept it, even though we've got it on oath, we've done further investigation, something has happened, something is not right, and the state was absolutely fine with it. That is the other advocates who were dealing with it. They had no problem at all, and Colonel Lazarus had no problem either. In fact, he was in court at the first day of the case, and he was the arresting officer. Then we say also, with respect, if you deal with all the provisions of subsection 64 to 9 of the Criminal Procedure Act, every single one of those were in favour of the appellant. He won't undermine the functioning of the bail system. He's not a danger to members of the public. He's not going to interfere with witnesses. All those grounds on which bail are normally considered and refused, every single one of those grounds, respect my lord, were in favour of the appellant. There was absolutely nothing. Emotional ties, family, etc., everything was in favour of the appellant. And then we quoted the matter which was attached to our heads of argument, that where there's a speculation or possibility of a person absconding or temptation to flee is present, and the learned judge dealing with that in the State versus Napoleon, he says likelihood, probability is a required standard. And he said the magistrate erred in his approach to the matter. The high water mark was that a strong prima facie case and the possibility of the appellant being in prison may provide a temptation for the appellant to evade their trial. So you need a lot more than that, and there's unfortunately a glaring lacuna in the affidavit of the respondent in this matter. There's nothing, not a word at all relating to this about the strength of this case, and I've got information he's going to plead. And then in particular, if you look at the appellant's conduct, and this is an important aspect, my lord, if he's set up, and according to what the learned magistrate found, well, what was the point of going to state capture? What is the point of going to the Special Investigation Unit? What is the point already in 2018, undisputed, the previous legal representatives representing him, going to Colonel Lazarus, offering your help, offering your assistance in any prosecutions that might ensue? And unfortunately, the present state advocate that's now dealing with the matter, that unit wasn't even set up or in existence by the present state president of the Republic of South Africa. So all this was done prior, there's no dispute, it's all common cause. If you wanted to make another life, and you earned this money, and this was your money, and you had reserve bank approval, you could have gone. You didn't have to go to state capture, you didn't have to go anywhere. So that whole argument, with the utmost respect, to me, and I'll make a submission of respect, doesn't take the matter any further when you have a look at all these sites in the Republic of South Africa. We then deal in particular, my lord, that, and we set this out in paragraph 34. Then I have to mention this because I don't know what the legal magistrate was referring to. I think you can read from the record and read between the lines. This is at paragraph 35. And he started comparing the appellant to the alleged, because there's been no trials and it's all allegations of the serious crimes in regards to probably, you're talking up to, it could be billions, maybe even $1 trillion, according to the auditors, of what the Gupta family have allegedly done in the Republic of South Africa. And that's all allegations. It still has to be proved. They still have to deal with the matter. And he's saying, well, I don't want to land up with another Gupta on my table. And comparing the appellant in this matter, who's sitting there, or sitting at the request of the magistrate because he couldn't stand because of the oxygen and the medical condition, to compare him to the Gupta family. And I think we have to deal with it because this was one of the findings of the magistrate. And the difference is, in this particular case, everything has been declared to the Reserve Bank and the South African Revenue Services.
Sorry, was documentation furnished to the state?
Nothing.
From the receiver and from the treasury?
Well, the investigating officer confirms it in his affidavit. I can refer you to
yeah, I saw that.
Yeah, no documentation.
But no documentation was furnished?
No,
okay.
Nothing at all. But I can assure you all that documentation will tie up once we have a chance to compare the figures. Everything was done within the allowance. Everything was done in accordance with the law. And that's the big difference between the appellant in this matter and comparing him to any other names or people that have allegedly taken money, and we won't go into how they got their money and what happened, of taking money illegally out the country. If it was illegal, that's the big difference. Then the other aspect is the learned magistrate didn't take into account that prior to this, no previous convictions, lived here his whole life, born here, unblemished record, fixed ties, business, family, etc. And he didn't realize that by denying him bail, not only you're affecting his family, you're affecting any business that he might want to do in South Africa, etc. And in regards to the case itself, in his affidavit he put there, I've got a legal defense of the case, and in fact I'll be making representations, and in fact, with the utmost respect, if anything, and the state needed anything, he's the one who could assist the state in regards to who they allege were the beneficiaries or who received the benefit in this matter. But I'm not going to take that much further. We then deal with the question of your constitutional right to freedom, and we submit that it should only be lawfully curtailed if the interests of justice so require. And we say in particular that if he's released on bail, subject to reasonable conditions, we say he will not interfere with anyone or anything if released on bail. He's not a danger to society. He won't undermine or jeopardize the objectives or proper functioning of the criminal justice system. And we submit that he's not a flight risk. And we submit at the end of the day that if bail is in fact upheld, and if he is upheld and he is released on bail, we submit, but we leave that obviously in the hands of the court. This is only a submission that bail would be fixed in the amount of 50,000 rand, which I think even myself and my one learned friend were more or less in that region. He in fact wanted more, and we were doing a little bit of telephonic discussion as to amount. And we say that he will reside at his residential address. Obviously,
is it the same residential
same
address?
Residential
because
address. 97 Helderfontein Estate.
I gleaned from the papers that Colonel Razras says he was no longer.
No, he's there. That is his address. The sale fell through. The bank were trying to force a sale, and the sale fell through. I think it was the 9th or 10th of October. There was a public auction, and the guarantees weren't put up in the sale. So he's still living there. He also has to appear at 8:30 on the 3rd of December 2020, together with the co-accused. We also submit he mustn't apply for passport or any other travel documents until the finalisation of this matter. And the reason that we put that in is because passports, one is lost, reported, and obviously that's the embassy or the consulate. And the other one, even though it's in the possession of Colonel Lazarus, it's expired.
All right, you're watching live visuals of the bail application for Angelo Agrizzi. At this time, it's just gone 11 o'clock. I want to get you a quick check on the headline.